10 things all lawyers should know before stepping into bankruptcy court. Most of these issues are discussed more thoroughly in my other videos. However, I thought it would be helpful if I summarized a lot of these issues. First, visit the court's website before you appear in bankruptcy court. It contains links to our local rules, our forms, our administrative orders, and our guidelines. Local rules provide a guide of what the court expects from practitioners. And many forms that are linked can be used with only minor changes. Guidelines are exactly what they sound like. Guidelines of what you should be doing. On our website, by the way, are the judge's list of procedures and preferences. Please remember that although you can look at this various information on the website, judges and staff and case managers cannot give you legal advice. Number 2, be courteous and professional. Follow the court's guidelines for courtroom decorum. That includes making sure you're courteous to the court personnel, opposing counsel, the parties, U.S. Trustee's office, and even the court security officers. This applies in the hallway, in the 341 meeting room, in the conference rooms. It applies whether you're on the telephone or communicating by email. You're also expected to dress like an attorney at 341 meetings. 3, learn the law before you come to court. It is not okay to start out by saying you don't practice bankruptcy court, so you really don't know what you're doing. As soon as you say that, you've lost all credibility with the court. You are required ethically to learn enough to present your argument. And if you sign the pleadings, you're certifying that you're familiar with the local rules. I might add that Collier in Bankruptcy and Chapter 11 Theory and Practice are good resources. 4th, the bankruptcy court is a trial court. The rules of evidence apply. You should not make speaking objections. 3 words in an objection are all you need to do. File motions in limine prior to court. Documents must be admitted for the court to consider them. Exhibits to the pleadings are not admissible automatically. Think about evidentiary issues prior to trial and use offers of proffer even on uncontested matters. 5th, obey the rule of 5 and 10. Simple matters should be 5 pages in length and you should use no more than 5 minutes of argument. Complex motions should be no more than 10 pages and take less than 10 minutes to argue. Written materials should be concise and to the point. Make sure you state the relief requested and legal basis in the first and last paragraph. Make sure the relief you're seeking is plainly stated in your request. Consider whether you need an evidentiary hearing or an emergency relief, and if you do, look at the judge's procedures to ascertain how you obtain an evidentiary hearing or emergency relief. 6, there is no invisible jury. We're used to being trier of facts and we've heard it all. A low-key presentation is best. Focus on the laws and the fact and present them logically. 7th, telephone appearances are encouraged on routine matters. Review the website to see how you arrange it. All judges in the Southern District of Florida now authorize the use of court call. Telephone appearances, however, are not permitted on contested Chapter 11 confirmations, any Chapter 13 motion calendar, and any evidentiary matters. 8, everything is filed electronically. You must get a CM ECF certification if you file a debtor's petition or more than 10 pleadings a year. All pleadings, as I said, are submitted electronically, as are all orders except for in dire emergencies. 9, everything is subject to due process. Due process requires adequate and reasonable notice. The bankruptcy rules and local rules contain additional specific requirements. The moving party typically must serve a motion and notice of hearing. If the notice is not given, the relief cannot be granted. Remember to file a certificate of service on all motions and notices of hearing. Finally, try to resolve disputes without court intervention. The bankruptcy practice is a very small practice. The bankruptcy judges expect the parties to talk and attempt to resolve matters. They are not happy when you bring matters before them where there is an opportunity and was an opportunity to resolve the matter without a hearing. I might add that the local rules require consultation before you file any motion. Please follow those local rules. Thank you.